Hi, my name is Doug Small, and I'm here to talk with you today about getting ready for your deposition. A deposition is a part of the case which we call discovery. We have the initial beginning of the case, which is the filing of the complaint, and then the end of the case is where we have your trial, and the part in between, most of that is involved with discovery, which is the process of discovering or obtaining information about the case. One of the aspects to a discovery is a deposition. That's where you are asked questions by the other attorney about what occurred with your claim. Beyond that, we can also do depositions. We can ask questions and sit down with the other driver or the other parties involved with the incident that we're representing you about. And we can also acquire information by request for documents. We can depose witnesses. That's all part of the discovery process. Now your deposition. It usually takes about an hour to 2 hours to do a deposition. You shouldn't be afraid of it. You're going to do just fine. You're going to walk out of this conference room without any broken bones or anything like that. You're going to do just fine. In a deposition, the typical areas of questioning that occur are asking you some background questions about who you are, asking about the incident that led to your injuries, what your injuries are, your treatment, and then how you're doing today. Those are the basic categories. Your deposition will likely take place in our main conference room, which is where I'm at right now. We have a couple other conference rooms where it could take place at. In the deposition, we'll typically have a court reporter sitting here at the end. It's usually a lady. She has a little typewriter box that you've probably seen on TV shows with courtroom scenes. She'll be taking down what is said during the deposition. I usually have the other lawyer sitting right here. You'll be seated across in that chair, and either Ed or I will be seated in the chair next to you. So that's the setup. Again, it takes about an hour to 2 hours to do a deposition. And you're going to do just fine when we talk about it. Now let's talk about some details about the process. I now want to talk to you about the goals of a deposition. As I mentioned to you before, in a deposition, we're not in trial yet. It's a discovery part of the case, so it's a different scenario. In a deposition, the other attorney will be spending most of the time asking you questions. And I will have maybe a few questions or perhaps even no questions in the deposition. It's a way, again, for them to acquire information as part of the case. So in doing that, we have three goals that we want to try to look for. First is we want you to tell the truth. We always tell the truth. The worst thing that can happen is we don't tell the truth, and you have no reason to do anything else but tell the truth. Second, we want you to be accurate in the testimony that you're providing. We don't want you to guess or speculate. We want you to be a good teller, an accurate teller of the information that's being stated. And then third, we want you to be a nice, polite, likable person. It's very important for that to happen. Because why? For three reasons. Well, for one primary reason, and that is that if that lawyer, the other side, leaves this conference room thinking that you're truthful, you're accurate, you can tell your story about what happened, and that you're a nice, likable person, they're going to be thinking that you're going to be very effective at trial, because a jury hearing you testify, and they're concluding that you're truthful, you're accurate, you know what happened, you're telling them what happened, and you're a nice person, a likable person, they're going to be much more inclined to give you a very favorable verdict at trial. So those are the goals that we have for a deposition. Now I want to talk to you about what I call the 4 golden rules for being deposed. You know, the good Lord took 10 rules in the 10 commandments, but I'm going to give you only 4 rules to do a good job in a deposition. So rule number 1 is, we've already talked about this briefly before, and that is telling the truth. It's always the most important thing. Again, you have no reason to do anything else but that, so we always tell the truth. So rule number 2 is to listen and understand the question. You're going to see or hear that all 4 of these golden rules are very, very simple. But to do them takes some effort. It takes some concentration on your part to do them well. In fact, I've had many people tell me that after they do a deposition, that they walk out of there feeling tired. It isn't tired because of physical exertion or anything like that. It's being tired like when you're in school, having taken a test, or in work where you have something you really got to concentrate on. It's that type of tiredness, because we want you to concentrate that much on what's going on in your deposition so you can do the best job possible. So going on to rule number 2, again, very simple, listen and understand the question. In doing that, take your time. We're not in a hurry, we're not in a rush. It's perfect when our clients, when they're asked a question, there's a slight pause between the time the question's asked and the time you begin to answer, because that means you've listened to the question, you're thinking about what the appropriate answer is. If you're asked a question, you don't understand it, you're unclear about it in any way. You know, as a lawyer, we don't always ask good questions. We can get our words all bollocksed up like anybody else can. If we are asked a question you don't understand, ask the other lawyer to restate it, and he or she has to do that. It's typical in a deposition of our clients that anywhere from a couple times to perhaps even a couple dozen times, they may ask the other lawyer to restate the question because they feel uncertain about it. Now, of course, if you understand it, we want you to answer it. There's no reason not to do that. But again, if you're troubled by it in any way, ask them to restate it. Also, it's important that when you listen and understand the question, that you let the lawyer get done talking before you speak. And again, the lawyer needs to do that for you. And if he doesn't do that, we'll be objecting to make sure that that's allowed. Because only one of you should be talking at a time. Because a court reporter who's sitting down here at the end of the table with their little typewriter box can only type down what one person is saying at a time. So take your time, listen and understand the question. One other thing before you go on is that it's a deposition. You don't do it every day. Chances are you've never done a deposition before in your life. So you're likely going to be nervous. And for me, that is a good thing. Because when you're nervous, that means you care. And if you care, that means you're going to be paying attention to what's going on. And your nervousness is a natural, instinctive reaction about doing something you're not familiar with. It goes back to our caveman or cavewoman days when they were in the forest or the woods and they hear a snapping of a twig and they don't know if it's a lion, a tiger, or a bear. And so they're nervous about that uncertainty. The same thing happens in a deposition. But when that happens, that means you're aware, you're more on top of things, you're attentive, you're paying more attention to what's going on in your environment, and you're going to be better reactive. It's a self-defense mechanism. So being a little bit nervous is a great thing. So don't feel bad about being nervous. You shouldn't be petrified because you're going to find out that a deposition really isn't that hard of a thing to do. All it is the other lawyer asking you questions about something you know more about than any other person in the world. So that's rule number 2, listen and understand the question. Rule number 3 is, next to telling the truth, is the most important rule, and that is to give a responsive answer. Generally speaking, your answer should be short and sweet and to the point. If you're asked a yes or no question, you should answer with a yes or no answer. You shouldn't feel like you have to go on to explain why your answer was yes or no. If you're asked where you live, a simple example, you should say, I live at 123 Main Street in Osceola, Indiana, and stop. You shouldn't go on to say that, well, I live there now, but before that I lived at 456 Elm Road in Mishawaka, and before that I lived at Schenectady, New York, because that wasn't the question. The question was only, and remember, you listen, you understand the question, and then what is the responsive answer to that question? Where do I live? I live at 123 Main Street in Osceola, Indiana, and that's your answer. Being responsive is very important because studies have shown that people who give responsive answers are much more accurate than people who are a talker. They go on and on and on. They become sloppy and they tend to make more mistakes than anybody that does just a short, sweet, and answer right to the point. And the other major point about giving a responsive answer, besides being accurate, is that your deposition will take a heck of a lot less time because you won't be talking as much. And believe me, if you're giving an answer and you're going on and on and on, it's going to lead the other lawyer to ask you questions about these other things that you've been talking about that chances are have nothing to do with your case. And it's just going to take longer and longer for your deposition to be done. So rule number 3, again, next to truth, is the most important rule, is give short, responsive answers to the questions that are asked. And then lastly, rule number 4, is if you're asked a question you don't know the answer to, or you don't remember that information, just simply say that. I do not, and we do not, need you to be like an encyclopedia. We don't need you to have a perfect memory. I don't expect you to remember everything that was involved with your incident or your treatment or even what happened yesterday. So if you're asked a question you don't remember the answer, just say, I'm sorry, I don't remember. If you never knew the information, just say that. Don't guess or speculate. I could guess or speculate about the answer, but we don't need that. Remember, one of our goals is to be accurate. So you give accurate information about things you really know and remember. Now let's talk a little bit more about memory. It's kind of hard to quantify memory. But if you're more than 80% or you're less than 80% certain about something, I'd rather have you say, I don't remember. If you're almost certain, if you're at 90 to 95% certain about your answer, it's okay to give that answer, but I want you to qualify it by saying, I'm not quite certain, I think this is accurate, but I'm not quite certain, but I think, and then explain it. But if it's more than 90% less, or not at 90% of certainty, then I'd rather have you say, I don't recall. Again, we want you to only talk about things you know and remember. So those 4 golden rules, they're very, very simple. But to do them well takes concentration, and that is to tell the truth, to listen and understand the question, to give responsive answers, and if you're asked a question you don't know the information or you don't remember it, simply to say that. So they're very simple. Again, it takes concentration and focus to do that, but again, if you do those 4 things, you're going to do a great job in your deposition. Now I have one last general area of things to talk about, and we'll be done talking about preparation for your deposition. Well, I'd like to talk with you now about a few general points about deposition, and then also go on to talking about your injuries and losses and how to think about those. So first, some general topics. First, it's good to arrive here about 15 minutes before your deposition. I don't need you to be here a half hour early because you'll just be sitting here twiddling your thumbs. And if you're here only a few minutes before, you'll be a bit bustled and hustled and your this will not be quite as relaxed. So 15 minutes is an ideal time to come. In terms of a dress and attire, nice casual is the order of the day. I don't need you to come in a tuxedo or a ball gown, but I also don't want you to come in right from the work or out in the garden. So just nice casual is a good way to come into the deposition. About the deposition and then the questioning process. If you're asked a really broad, open-ended question, and we talked about this in giving a responsive answer, I don't want you to go on and on and on. So if they ask you to tell them everything about all your injuries following the crash or your fall or whatever it is that caused you to be hurt, you can go on about that for a long time, and we don't want you to do that. So if you get that broad, open-ended question, break it down into some subpoints or bullet points and then stop. So for example, you could say, I was taken to the emergency room, I had follow-up care with my family doctor, then with an orthopedic specialist, and then physical therapy. And then stop and then let them come back and ask you specific questions about those items. The other thing to talk about then is the questioning. Most attorneys are kind and polite and professional, some aren't. And some attorneys can't help themselves by asking a question that can get under your skin. I don't want you to get angry or frustrated with that. Again, one of our goals was to have you be a nice, polite person. And so if the attorney knows that no matter what he or she might do, that you're going to maintain that collegiality, that good faith way of dealing with somebody, it's going to be fantastic because the jury's going to like you. So don't get angry at the lawyer even if he gets you a bit upset. I don't want you taking notes in the deposition because all that will do is lead the other attorney to ask you questions about your note-taking. You'll likely be asked questions about what you've done to prepare for the deposition, and that's a typical question, and the fact that we're doing something to help prepare you for the deposition is totally appropriate and proper, so don't think that there's anything inappropriate about that. You can tell them that we met, that I spoke with you, or that Ed spoke with you about the deposition process and what to expect. They may ask you some questions about what documents you reviewed, and we will likely have given you answers to written questions we call interrogatories that we did together. We may have you look at some other documents that are involved with the case. We may give you a copy of a settlement letter that we did for you, assuming one's been done. Most cases that they've been done by the time of a deposition, but not always. So you can tell them about those documents that you looked at. We'll also likely give you 2 other documents which has the golden rules that we've been talking about earlier. There's another document that's called the 87 rules, which you're going to be thinking, 87 rules, are you crazy? But I give that because it gives you a good oversight and perspective about the deposition process. I don't need you to memorize those 87 rules. But those 2 documents, the 87 rules and then my 4 golden rules document, I don't want you to tell the other lawyer about because those are attorney-client type of things that you and I are talking about the preparation process, and they're not entitled to know that. But the factual things, the interrogatory answers, any photographs, documents like that that we've given you to look at, a settlement letter, you feel free to tell them you looked at those things. In dealing with the other lawyer, most lawyers are professional, they're not overly obnoxious. Some can't help themselves, and even ordinary lawyers can sometimes ask an offensive question. I don't want you to get mad about that. I want you to treat that other lawyer like he was your priest, pastor, rabbi, guru, whatever it might be. We're not there to argue with him. And then remember, one of our goals in the deposition, that rule number 3, is for you to be a nice, polite person. So it's good for him to realize, or her to realize, that you're going to be that type of a person regardless of the type of questionings that are being asked of you. Next, I'd like to talk to you now about pain and issues dealing with that. Oh, no, wait, before we do that, there's one other thing before we get to that. I want to talk to you about speed, time, and distance questions. If your case is an auto case, and this only really applies to that, you can be asked questions involving speed, time, and distance, and that's an equation. So for example, if you were to tell me that you traveled to get to our office today an hour exactly, and you traveled average speed of 55 miles an hour, I know that wherever you came from is 55 miles away. And no matter how you did that equation, even if you just told me you traveled for 13 and a half minutes and you traveled 47 miles, I could figure out how fast you were going to go that distance, which would probably be pretty fast, in fact. So the thing about those equations is that with an auto accident, they happen so fast. For some people, time speeds up. For others, it slows down. But inevitably, your perspective is going to be warped or distorted because of the emergency nature of the event. So when it comes to speed, time, and distance, unless you happen to know as an objective measurement, where you were in relationship to a tree or a light or something where you have that objective reference, I'd rather talk to you about just having say we were very close, because obviously you had to have been very close for the crash to have occurred. When it comes to time, I'd like you to say typically that it happened very fast, as opposed to saying it took 2.5 seconds or 10 seconds or whatever, because chances are whatever you estimate is going to be wrong. I had a case a few years ago where I was deposing a lady involved in a crash with one of my clients, and I had her testify some questions involving those things, and when you did the math, it worked out that she had to be traveling over 240 miles an hour at the time of the impact, which of course she wasn't. But the estimates that she had, when you did the equation, worked out that way, which, again, we know that those estimates were wrong. So when it comes to time, I would prefer, unless you were timing yourself on a watch, which I trust you weren't, or you'd be guilty of negligence yourself, I'd rather have you say it happened very quickly. When it comes to distances, say that was very close, unless you have an objective point of reference that you can verify that what you're giving is objectively true. In speed, I don't have as much problem with speed estimates, because most of the time we've driven so long we have a pretty good feel for that. But again, once you give an estimate, stick with it. And so if you say, I believe the other car was going between 60 and 70 miles an hour, stay with that. If they try to say, well, could he have been going 57, or could they have been going 55? If you start to creep down to these different numbers, your estimate will become worthless. So once you make an estimate, whatever that might be, if you feel comfortable giving it, stick with it and don't change. If they prod you, just say, no, I'm sorry, I'm going to stay with what my estimate was. That's what I believe it is, and just stick with that. Now, the last thing I want to talk to you about before concluding is about pain. Comes back to truth, okay? And another way of saying it is, I don't want you to overstate your pain or understate your pain. So I want you to tell it like it really was or like it really is. So I don't need you to be a John Wayne or a Clint Eastwood type where you just got shot in the arm in a movie and they ask you how he feels and Clint says, oh, I feel fine. Baloney, that has to have hurt. And on the other extreme, I don't want you to be like some people we meet in life where you ask them about how they're doing, and for the next 20 minutes they're trying to regale you with all their ills and problems and all those things that they have health-wise. So I don't want you to be a whiner. I want you to say it just like it was and like it is today. They may ask you to state your pain on a 1 to 10 scale. We do that because if you go into hospitals, they typically have a little chart that asks you to rate your pain on that way, with 10 being worst. In your life, you may have had worse pain than after this incident that you're seeing us to help you with today. It could have been childbirth if you're a lady. It could have been some other incident. So if this crash is not your worst pain, you shouldn't say it was a 10 pain, because it wasn't your worst pain. But if it was your worst pain, then you should say that. It's saying it like it really was, or like it really is today. And at the other end of this pain spectrum, the everyday pain for me is one thing. Accident or a trauma injury pain is something beyond that. So in everyday life, we may have a crink in our neck or something that just bothers us a little bit, that's like a 1 or maybe a 2. A crash pain is typically going to be something more than that, a 2 or 3 or above, whatever that might be. So when you look at that pain situation, typically that's the ranges we're looking at, anywhere from a 2 or 3 to up to a 10. And also after a crash, our pain doesn't always stay. If we were at a 10 after a crash, it doesn't always stay there, right? We get better over time. So usually our worst pain is the day of the crash, or for a lot of people, it's a few days afterwards when they get that achiness and soreness that their whole body gets impacted by. And then it gradually gets better. But then you may have some times where it spurts up because of you're trying to get well again and you re-aggravate things because your body's not used to it. But typically it's going to be a downward trend, and you should reflect that in your testimony, because you are going to gradually get better and those pain symptoms are going to hopefully subside for you. So that's some thoughts about the 1 to 10 pain scale. With this paper I'm going to give you, it has what we call the 5 descriptors of pain. And I want you to think about these before your deposition, so when you're asked these questions, you're better able to answer them, and you're not later saying, geez, I wish I would have thought about that after your deposition was over, so your information is more complete. So descriptor number 1 is the type of pain. Was it sharp, burning, aching, throbbing? Think about how that pain was, and it may have changed over the course of time of your injury and recovery. So think about that so you're better able to explain it. Second descriptor is frequency. Right after the crash, your pain may have been constant, but then it may have become periodic. And when it became periodic, you're going to have frequencies about how long it lasts. Typically, it's going to be longer lasting and gradually get down to a smaller time frame. But think about that frequency. When you would have pain, how often would those periodic symptoms last? And then with that frequency, a couple of things follow with that. Triggers, what would trigger it? So when you get to the periodic time frame, certain movements may have made you worse. Weather changes can cause that. A variety of different circumstances can cause that. So think about what those triggers are. And then when you are triggered, duration, how long will it last? Again, it could vary depending upon what happens with you, but think about when you are re-triggered, so to speak, with your pain symptoms, what's that duration of time that it'll continue to get better, or to trouble you, I should say. And then lastly, related to that is relief. That's the 5th descriptor, is what can you do to get better? That could be rest, some pain medication, certain movements, further therapy, exercises, that are all the types that might be involved with that. So again, the descriptors are type, frequency, triggers, duration, and relief. So think about that before your deposition so you're better able to answer those questions. And one last thing to talk about with pain is it's typical for a defense attorney to ask you 2 questions. One is, are there things today that you can no longer do at all because of your injuries? And then the second one related to that is, are there things you can still do but you can't do as well, or only with pain or with some limitation? So I like it for my clients on a piece of paper to write down on there what those impacts are. And I think about life in 3 different kind of segments. One is our work life, second is our family life, and third is what I'll call our social, personal life. So if you think about what the impact is of your injuries in those areas and write down 2 to 3 or 4 areas where you have those impacts, it helps you to better be prepared when you're asked that question, because it almost always comes in the course of a deposition. And if you thought about it, you wrote it down, you're better able to remember and have that in your mind and better able to answer those questions. So it could be at home. If you have a little one, having difficulty picking up your infant child and hold of them, or to play with your child. If you're a mom or dad that helps without playing soccer or baseball, those type of things. At work, things you can no longer do, or accommodations that had to be made for you to do your work, changing your seating, how you could work with a press, whatever it is that you're working with. And then the social, the things you can no longer do, bowl, jog, go out and do things with your friends, go to movies, whatever those impacts were in your social life. So those are the things I want to talk about there. I have one last thing to talk about and we'll be all done. Okay, just a couple of last things to talk about. First of all, if you're involved in an incident where it took place at a location, so it could be an auto accident, a fall, a construction matter, if you can, and if it can be arranged in a safe way, we'd like you to go back to that scene of your injury and just to look around. It could be an intersection accident, and even though you think you kind of remember everything, it's amazing if you go back and just stop somewhere where you can pull off into a parking lot near there and just look around, see where the signs are, how the lanes are configured, where the warning signs might be, a warning of the approach of a stoplight or a stop sign. It's just good to go there and look back and just generally refresh yourself with a recollection. Again, I don't need to memorize it. I don't need you to take measurements. It's just a general refresher of your recollection about that scene of the incident. In a few minutes, either Ed or I will be meeting with you to go over some specific things about your case, to talk about your case specifically. And so we look forward to doing that. I hope you found this process informative. The paperwork that we have, again, is there for you to look at, not to memorize, but just to generally refresh your recollection. And remember, you're going to do a great job. You have nothing to fear in this matter. You're the person that was hurt here. You're the innocent party. All you need to do is tell the truth, be square with them, be a nice, polite, respectful person, like I'm sure you will be, and you're going to do a great job. So we are honored to have a chance to represent you in this matter. We look forward to getting an outstanding result for you. and a meeting with you in just a few minutes.